Major breaking news. The U.S. Court of Appeals for the Ninth Circuit out of California has just issued a machine gun case touching fingers with the Second Amendment. But most importantly, you're not going to believe this crazy ruling by this 2-1 decision. A powerful dissent by potential future Supreme Court Justice Lawrence Van Dyke is out there, but we have to break this down. And again, it's a reaffirmation that we sometimes have to talk about other areas of the law so you understand it, so we can protect our right to keep and bear arms. It all works together, even if it's not specific to the Second Amendment. And this case of United States versus Kitson is another example of that point. Let's talk about it when we come right back. Hey folks, I'm Mark Smith, host of the 4 Box of Dine, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you. 2025 Gundy's Awards. And you know what I'm going to say? I'm going to remind you to vote every single day between now and December 15th if you're so willing at thegundys.com for Mark Smith and the 4 Boxes Diner to be the top voice of the two. Very stiff competition this year. It's very hard to repeat. I won it last year, but we can do it again. I think we can win again. Fingers crossed and candles lit. So, if you're so willing, go over to thegundys.com and vote for Mark Smith for Boxes Down every day between now and December 15th. I would appreciate your support. All right, folks. So, we have this case of United States versus Kitson. It's kind of an interesting case, and it really just goes to show you that the left-wingers in America, in my view, just don't care about the law. They just want to go do what their feels want them to do. And they're motivated by their feels, their feelings, their emotions, and not the logic of the law. And that's a problem in cases where you may have bad people or bad facts because, as you know, bad facts make bad law. And people, when they react in the law emotionally, at the court level, when you're a judge, you can get rise to, in my view, unjust outcomes. And that is the case, in my view, in this decision in the United States versus Daniel Kitson by the Ninth Circuit Court of Appeals. In the 9 out there in San Francisco, 2-1 decision upholding a conviction. Listen carefully, folks. We're going to get a little geeky upholding a conviction. Under 922, dealing with possessing and transferring machine guns not registered. Under the not registered under the pre-1986 NFA. Okay, now this is kind of an interesting fact pattern, and then I'm going to explain to you why, unlike other cases where people possess illegal machine guns, this is dramatically different. But the majority, the 2-1 judges in the majority, won a Jimmy Carter appointee. Who even knew Jimmy Carter appointees were still alive? But yes, there's one out there right now trying to rule against the Second Amendment and guns. And a Barack Obama appointee, a former RBG Ruth Bader Ginsburg clerk, John Owen, wrote the opinion over the dissent of Judge Lawrence Van Dyke. So anyway, under this conviction, this individual was convicted of violating 922 from possessing and transferring a gun supposedly to the federal government. Here's the facts summarized by the opinion. In January 2020, federal agents learned that Mr. Kitson, a previously convicted felon, was willing to sell a World War II-era Russian machine gun, which he acknowledged could not be lawfully transferred. An undercover federal agent posing as a firearms and drug trafficker exchanged phone calls and text messages with Kitson to make a deal. While Kitson did not physically possess the machine gun, hear what I just said, folks. While Kitson did not physically possess the machine gun, he arranged for Ray Bonahan, who had the weapon, to finalize the transfer. The federal agent and Kitson drove to Bonahan's location, where they negotiated the final price and exchanged cash for the machine gun. The federal agent remained undercover, and the United States Marshal Service subsequently arrested Kitson. Okay, did you see what I just described there? This is very important. The details matter at the highest levels of law. Here's what happened. Mr. Kitson never possessed this World War II-era Russia machine gun. He never possessed it. Instead, he arranged for a transfer of the gun from an individual, Mr. Bonahan, to an undercover federal agent who was engaging in a sting operation. So, Mr. Kiss never actually touches the gun. He never possesses the gun. He arranges for the transfer. That's a really big deal because when you read the relevant part of the Federal Crime Statute 922, it literally exempts from the crime transfers of machine guns to, drumroll please, the federal government, which is exactly what happened here. It was a transfer from Mr. Bonahan to a federal agent who happened to be undercover, but he was a federal agent working for the United States. He was the US government, and Mr. Kidd and Mr. Kitson arranged for this. Here's what the statute literally says, and it's a big deal to read every word, and you'll see what I'm getting at when you read it right here and right now. Section 922 provides, except as provided in paragraph 2 below, it shall be unlawful for any person to transfer or possess a machine gun. However, listen carefully, folks. This subsection does not apply with respect to a transfer to the United States or any department or agency thereof. Hear what I just said. The unlawful transfer law does not apply if it is a transfer to the United States or any department or agency of the United States. It's literally in the statute. So, what happened here was Mr. Kitson, he didn't possess the gun. So, you can't charge him with the unlawful possession of the Russian machine gun from World War II because he didn't possess it. He arranged the transfer between another individual and the federal agent working on behalf of whom? The United States. And there's an exception under the statute itself that says the transfers to the United States government are legal. It's not a crime. Nevertheless, what did this 2-to-1 panel hold? They got, as far as I'm concerned, they looked to their feelings, and said, well, yeah, we know that's what the language says of the actual criminal statute enacted by Congress, but we think it doesn't matter. We think that there's an exception. Listen carefully. There's an exception according to this 2-judge majority for sting operations for undercover operations, because we all know how brilliant our federal agents are when it comes to sting operations and undercover operations. We saw that in January 6th. We saw that in Ruby Ridge, and so on and so on. So guess what? This should have been an easy case. There should not have been an indictment because the transfer was to the federal government, which is an exemption. It's not a crime. But that's not what the 2-to-1 judge said. The 2 judges said, well, we know what the statute says, but we're going to rely upon decisions by other courts in other parts of the country to make the decision in favor of convicting and upholding the conviction of Mr. Kitson here. Well, needless to say, potential future Supreme Court Justice Lawrence Van DJK wrote a dissent and identified this obvious problem. This is a no-brainer, folks. Read the statute. You should never, as a judge, rewrite statutes. And if you're going to rewrite the statute in some way under the rule of lenity, you always rewrite it in favor of freedom, never in favor of the government. If there's an ambiguity or some debate about what it means, you always opt in favor of freedom over the government. But here, the 2 judges of the majority, a Carter appointee and an Obama appointee, of course, go the opposite direction in favor of the government and against the transfer of this machine gun. And Judge Van Dijak points exactly this out. Here's what he writes. Section 922. A exempts transfers of machine guns to the federal government. That exception contains no state of mind requirement. It merely states that a machine gun transferred to the United States is not a crime signed into the statute. And because everyone agrees that Mr. Kitson here transferred a machine gun to the federal government, this should be a fairly straightforward case. Period. Well, again, of course, the statute exempts transfers of the machine gun to the federal government. That is what happened here. It's not a crime under the language of the statute. So, what the majority says, well, we think there's an implied exception for operation stings, or sting operations, or undercover operations, whatever you want to call it. And Judge Van DJK says, no can do. That's absurd, because if Congress wanted there to be an exemption for sting operations or whatnot, they could have written that into the statute, but Congress didn't do that. And therefore, a Ninth Circuit 2-judge panel in the majority should not rewrite a congressional statute. And if you're going to do it, you should never do it in favor of the government against freedom. That's what Judge Van DJK says. Here's the observation he makes in his dissent about this exact point. Congress never carved out sting operations from its exception for transfers to the government. And even the majority's dive into legislative history fails to show that even a single member of Congress ever talked about sting operations when passing the statute. If Congress meant to carve out sting operations from the transfer exception like the majority contends here, then it makes sense that it would have actually done so. Of course, it's crazy, right? What you have here is the Ninth Circuit rewriting a congressional statute, rewriting a federal statute where someone can go to prison for a very long time as a felon, and they're rewriting it in favor of the government against the freedom, against the individual. That's not how courts are supposed to operate. When in doubt, in a criminal case, the criminal defendant wins. That's why we have the presumption of innocence and the beyond a reasonable doubt standard for convicting someone of a crime. And Judge Van Dyck makes this exact point, pointing out it's wrong for the courts to rewrite congressional statutes in favor of the government. Here's what he says here. The majority modifies the statute's text by adding a new unwritten element. Adding a new unwritten element under its holding. Mr. Kitson must not only transfer a firearm to the government, but must also do so knowingly. Courts often read state of requirements into statutes. So listen carefully, folks, to mitigate criminal liability, such as to require that the defendant know the facts that make his conduct illegal, cited the Staples case. By the way, this US Supreme Court case on machine guns, but I'm this Judge Van DJK, but I am unaware of any case, and the majority cites none, that requires the opposite. That is, the majority here does not point to a single case where a federal appeals court has required a defendant to show an innocent state of mind to avail himself of an exception to a criminal law's prohibition that contains no textual requirement. So what Judge Van DJK is saying is, look, the burden of proof to establish every element of a crime is on the government to show beyond a reasonable doubt. What just occurred here is that the majority of this court basically said, well, yeah, but Mr. Kitson has to prove to us these other things. They just made it up to make sure that his conviction for transferring a machine gun that he never possessed could be upheld under the law despite the plain text. And again, this is an example why when I cover other topics other than Second Amendment jurisprudence, I do it because I want you to be the best possible Second Amendment advocate out there. And to do so, you have to understand other areas of the law. And here's an example of the improper way of these judges in terms of how they interpret and construct federal crime statutes, federal gun control statutes. It's insane what they did here. But I'm not shocked when you're dealing with two appointees by Jimmy Carter and Barack Obama. Results-oriented all the way, as far as I'm concerned. No shock here. The last point I want to make here is something also Judge Van Dyck points out, and that's this. The left in America for many decades had a simple game plan in the courts. They would issue insane left-wing rulings in various courts in the country, and then other insane left-wing judges would rely on those insane left-wing presidents to build up a body of law in favor of whatever they want to do. And that's what's happening here. So rather than actually reading and analyzing the plain text of the statute of 922 of the federal gun control laws, instead of that, this majority of this three-judge panel looks across the country and finds other courts that basically have ruled the way they want to rule. And they rely on these other courts as opposed to doing the analysis of the statute itself. So basically, they're saying that we care more about what other federal judges have to say on this question than our own interpretation of the statutory text that clearly exempts from the crime transfers of machine guns to the federal government. And they basically said, well, I know that's what it says, but we have a different take on it for various reasons laid out in this long opinion, which I'll put a link to in the description below. I should also note that there was a reference here, a little bit of discussion about the Second Amendment, but basically nothing particularly substantive. Judge Van DJK urged that the case be remanded on the Second Amendment question. I'm not sure that was necessary here, but the point is, all this is moot when it comes to the Second Amendment in this particular case, because the reality is they just convicted him, and they just cite something to say, well, machine guns are not protected arms under the Second Amendment. And from a pro-Second Amendment point of view, it's actually not necessarily a terrible outcome because, as I point out before, until we win three things at the Supreme Court, AR-15s, semi-automatic rifles cannot be banned, magazines over 10 rounds cannot be banned, and suppressors cannot be banned. Until we win those three things, We should not talk for a moment about pushing a machine gun case to the Supreme Court because we simply don't have 5 votes today. But one doesn't know what the future holds. Maybe the composition of the court will change in some favorable way, and then we can talk about machine guns in a few years. But we should not be talking about machine guns and the US Supreme Court right here and right now, because we're not going to win it today. Okay, folks, hope you enjoyed today's episode. Make sure you follow me on X4 Box of Diner. Don't forget to subscribe to YouTube and Romo, and I talk to you again real soon. I hope here at the 4 Boxes Diner, orders up. Table 2A.